Court does call the case of the people versus Stephen Johnston.
In favor, Rachel McDuffie for the people. And Allison on behalf of the people, Your Honor.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Johnston.
All right. I put this over to this afternoon. What have we determined?
Yes.
Good evening, Your Honor. Well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up.
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give a change this morning.
Kristen Kinduski, Your Honor.
Okay, help me. Name.
Can we vote, Your Honor?
Yes. Counsel. Go ahead. Go ahead.
Yes. So in addressing the prosecution's request for no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Conkey there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that no contact order was needed. The alleged complaining witnesses in this case.
This is not your average courtroom drama. This is a high-tension battle of words and strategy where every sentence can turn the tide of a man's freedom. The case of Stephen Johnston begins with polite introductions, but the undercurrent is already filled with mistrust and legal maneuvering as the attorneys and the judge feel each other out. The defense wants to keep things moving. A prosecution has its eyes on controlling the situation, and the defendant himself sits in a quiet storm knowing the stakes could not be higher. What starts as a procedural check quickly morphs into a debate about restrictions and personal rights. Each word spoken is loaded with implication. One wrong statement could mean jail time or tighter control. The room feels calm on the surface, but beneath it is a silent clash of willpower and perception. This moment is the start of a legal chess match that will decide more than just bond conditions.
Before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, well, between the time of Judge Conkey's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that conduct. Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
Well, context may be changed. He has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a evaluation of his previous probation. So
right, okay, so that we're not getting, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess. in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then change the bond conditions on the case. You would agree with that, would you not, Mr. Buckovich?
Yes, I would understand what you're saying, Your Honor.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. You're gonna wait. He's waving up.
Yeah, we get you in front of Conky.
You know what, Your Honor, I might as well just wave up the conky.
Okay.
Okay, if that's what you wish to do.
The judge now steers the discussion toward the issue of contact orders, and it becomes clear this is no minor matter. The defense leans heavily on past rulings claiming prior judges allowed consensual contact, but the prosecution counters with a darker view pointing to troubling phone calls that could be seen as attempts to obstruct the process. The defense insists those calls were harmless, yet the judge reminds everyone that context changes everything. What is said can transform legal permissions into legal violations in seconds. This is where courtroom nuance becomes dangerous for the defendant, because the wrong perception can undo months of legal ground gained. One side frames the calls as non-threatening, the other paints them as a red flag for escalating behavior. The tension is no longer hidden, it is growing in plain sight, and the next few exchanges will decide which narrative the court accepts.
Sir, you,
Tells me addressing bond and not changing when it was no contact with her. That's what I was addressing. I'm not gonna be right towards you.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening, so I would still be asking for a,
you're saying they could be interpreted as a way of non-threatening?
yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Otisella, Mr. Buckovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and the magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue where his wrong privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised the red flag for me with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that the circumstances have clearly, if they were deemed to be appropriate back in January, have certainly changed by now.
The prosecution lays down its most forceful argument, yet painting a picture of repeated patterns and unbroken defiance. They remind the court of past sentencing hearings, past revocations, and past instances where the defendant ignored boundaries. They argue that whatever leniency was given in January no longer makes sense today. They point out that the new charges and ongoing contact prove history is repeating itself, and the stakes are higher than ever. The words are sharp, methodical, and designed to push the judge toward decisive action. This is a prosecutor building a case not just on paper, but in perception, showing that the defendant is not learning from past consequences, but is instead testing the system. At every step, it is a calculated effort to frame the matter as a public safety issue, and the weight of that claim hangs heavy over the defense table.
So the people are, again, requesting it simple, but straightforward, no contact whatsoever with this complaining witness in this case. Given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
All right, here's what the court's gonna do. Well, is he waving up or what's he gonna do?
He's getting funky.
Or did you wish for the adjournment, Mr. Frank?
Yeah, I'm quite confused on a couple of things. If I'm able to speak to you for a second. The complaining witness of who they are talking about, I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Kunke, Judge Kunke, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor. Was planted inside of a book bag. This is on transcript in Kunke's courtroom, Your Honor. And by me not being able to have contact with her is, I'm confused on it. I'm not being explained or talked to the reason why I cannot have conversations with my fiance and soon-to-be wife. When this drug charge had nothing to deal with her, it had to deal with a
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did are problematic.
what she did.
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Now, the defendant himself steps into the spotlight and the atmosphere shifts immediately. His voice carries frustration and confusion as he challenges the logic of keeping him from speaking to his fiancée. He insists she has publicly cleared his name and even accused authorities of planting evidence. He frames the restriction as unfair and personal, yet the judge zeroes in on the heart of the matter, that even permitted contact becomes dangerous when the conversation turns accusatory or coercive. The judge warns that certain statements can be damaging regardless of intent, but the defendant continues pressing his point. It is a risky move speaking directly without filtering through his attorney every sentence. Risks becoming part of the case against him, and the judge's patience is being tested in real time.
Okay, so that's the reason why I'm not able to have contact with her. She didn't put me in this predicament. Her doctor
Sir, I
did a
advise you
welfare
stop making
check on her.
statements. I advise you to stop making statements, because this is related to this case at hand.
And can you speak for me?
Sure, I've explained that. So statements can be used against
Do you
you.
wish for me to adjourn this rather than to
No,
do
give me
waiver?
the pen.
He's-
I'll go in front. I'll go in front of council, man. Have yourself a good day.
Really hope he didn't run or act that way. So are you signed this waiver of preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to.
I'm
get
not
it.
taking his waiver. I'm just gonna adjourn this out. You can talk to your client and he can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me.
I'm
I
not,
don't even know why. I'm making the findings based upon what's presented to me. But if he's gonna act this way, I'm just not having it. So,
Would you like to briefly pass this matter so I can speak to my
no,
client? Your
I'm
Honor?
not gonna pass it. I'm gonna
I'm
adjourn
not
this
mad.
to another
Oh,
day.
I'm not mad.
I'm
not
going to
upset.
adjourn this to give him 1 week out. We'll go June 5th, 2025. 9 AM, or
Mr.
his
Sim-
invite indicates, I am at this time going to change the bond conditions. I'm gonna leave his bond in its monetary amount as it's set. I am gonna order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also gonna indicate that there's no contact with Christian Kanuski. I'm gonna order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm gonna put up with his behavior, I'm not
I'm-
doing it. I'm
Your
done.
Honor, I'm.
Thank you.
I'm not upset, Your Honor. I said just. Okay. Not even upset at all.
The exchange boils over and the judge's tone changes from patient to firm. The court will not tolerate hostility and will not entertain back and forth that undermines order. What started as a bond discussion now ends with a clear shift in control. The judge revokes phone privileges, imposes a strict no-contact order, and sets a follow-up hearing. The defendant may see this as an overreaction, but in court perception often matters more than intention. One display of attitude can close doors that were once open. As the gavel's authority settles over the room, the message is unmistakable in this courtroom. You can fight the charges, but you cannot fight the rules and win. So, if you want to see more chaos like this, hit that like button and subscribe, because we've got plenty more where this came from, and trust me, you won't want to miss the next one.